Welcome to BS 361. Today we're looking at the forms of business ownership. Once the entrepreneur decides to start a venture or his venture, she has to decide the form of business ownership a venture will take. Ladies and gentlemen, it's important from the outset to note that there's no best form of business ownership. A type best for one entrepreneur may not be suitable for another. And also from the outset, it's important to take note that there are a number of factors or considerations that entrepreneurs take into account when choosing the type of business ownership. These factors include tax considerations. Each type of business organization attracts different tax obligations. Then also there's the issue of liability exposure. When you form a business, what happens to your personal property when the business fails? So you discover that for sole traders, when the business fails, they even lose their personal property. But this is different for limited companies, whose exposure is limited to the money the shareholders have invested in the company. Then also there's an issue of startup and future capital requirements. If you need huge capital to set up a business, it is advisable to set up a limited company as opposed to a sole tradership. When we come to the issue of control, a sole tradership has control over his business. But once we form a limited company, control and management is vested in two types of individuals. Control is vested in management, while ownership is vested in shareholders. Then the issue of managerial ability. A limited company, of course, requires people with different managerial acumen. Then we have business goals. Then the cost of formation. It's easier to form a sole tradership than to form a limited company. Management succession plans. A sole tradership, usually when the owner dies, the business also dies. But for limited companies, they have put in place robust succession plans. They know when the manager retires, they know who will automatically take over. Now, what are the forms, what are the types of business ownership? We have sole tradership, we have partnerships, we have limited companies. Let's look at sole traderships. A sole tradership or sole proprietorship is a business owned and run by one individual, perhaps employing one or more or two assistants and controlling their work. The individual's business and personal affairs are for legal and tax purposes identical. The individual's business and personal affairs are for legal and tax purposes identical, meaning that in the eyes of the law, there's no distinction between the business and the owner. The business and the owner are one and the same. What are the advantages of sole proprietorship or sole tradership? There are no setup procedures. The owner gets all the profits. The owner is close to customers and employees. The owner is independent and self-accountable. The owner supervises over the operations. However, sole proprietorship or sole tradership lack economies of scale due to limited capacity. They cannot produce a lot of products because they are limited in terms of labor, they are limited in terms of capital, they are limited in terms of skill. Then also there's a dependency on individual skills. Since this business is owned by an individual, he lacks certain skills. Expansion also has to be financed from profits. Usually sole tradership, when they go to the bank, because they lack the collateral, they cannot get a lot of, they cannot borrow a lot of money from the bank due to lack of collateral. The loss of personal wealth through unlimited liability. The sole tradership suffers from unlimited liability. When the business fails, the owner of the business does not only lose the money that invested in the business, he also loses personal property such as houses and cars. Then the death of the owner of the business may mean failure to pay taxes or succession problems. Actually, in our Zambian context, once the owner dies, most businesses also die. Partnerships. These are arrangements between individuals to carry on business in common with a view to make profits. Partnerships, however, involve obligations to others, and so a partnership will be governed by partnership agreement. So before a partnership is formed, partners have to draw a partnership agreement which will contain things such as sharing of profits and losses, the roles of partners, and also whether some partners will be active or whether others will be inactive. What are the advantages of partnerships? Partnerships benefit from expansion of capital resources. People have come together like lawyers, like doctors, and form a partnership. Then the partners come with a wide range of skills. For example, doctors can come up and form a partnership. Some doctors specialize in diabetes, and other doctors may specialize in pediatrics, children. Other doctors may specialize in bones. So these doctors will bring a wide range of skills. Equally for lawyers, some lawyers are human rights lawyers, others are constitutional lawyers, others are criminal lawyers, others are commercial lawyers. So when they form a partnership, they bring their wide range of skills together. Then also partners or partnerships benefit from spread of financial and operating responsibilities. Also, partnerships don't need to file or they don't need to publish their accounts. Disadvantages. Partnerships have limited ability. When a partnership fails, the partners will lose their personal properties. Disputes among partners may paralyze the business. Then also, the need to consult partners derails decision making. Then, of course, partners or partnerships lack separate legal identity, meaning that the partnership, in the eyes of the law, is not separate from the owners. Then, joint liability for other partners acts. All the partners are liable for decisions and actions taken by other partners. Then finally, but not the least, capital is tied up in the business. Having looked at the sole tradership and partnerships, let's now look at limited companies. Limited companies have a separate legal personality, and the liability of which shareholders for debts of the company only extends to the capital they contributed or invested. The shareholders, who are the owners, cannot be sued for debts of the company. This is called limited liability, and this is the major advantage of limited companies. Shareholders, who are the owners, cannot be sued for the debts of the company. In the eyes of the law, a limited company has a separate legal identity from its owners. Types of limited companies. There are two types of limited companies. There are private limited companies, such as Antwerp Milling of Luanshya, Dangote Cement of Ondola, Power Tools of Kitwe. Then we also have public limited companies, whose names end in PLC. Zambif PLC, Zambia Sugar PLC, Shoprite PLC, and Butter PLC. So let's look at private limited companies. Most private limited companies are owned by a small number of shareholders. There's a minimum of 2 and a maximum of 50. A private limited company's share capital will normally be provided by the founder or founders. business associates of the founder or employers, as well as venture capitalists. Public limited companies. Public limited companies are owned by a wider proportion of the investing public. A public limited share capital, in addition to the wider investing public, can be raised from the public directly through the sale of shares or through institutional investors, such as the National Pension Scheme Authority, Zambia State Insurance Corporation, or Zambia National Building Society. Advantages and disadvantages of limited companies. There's continuity of operation. Even if some shareholders leave the company, they sell their shares, or they die, the company will continue to operate. The company is a going concern. More human resources. Limited companies have a lot of workers and a lot of managers. More professional appearance. They can raise capital easily and therefore grow. Their ability to raise capital easily stems from the fact that they have collateral which they can use when borrowing money from the bank. Separation of business from owners. In the eyes of the law, the company is separate from the owners. Therefore, the owners have limited liability and therefore they can take risks. When the business fails, the owners will all lose the money they invested in the company. In terms of cons or shortcomings or weaknesses, limited companies have large overhead costs. This is due to the fact that they have a number of managers, they have buildings. Overhead costs are indirect costs. Then when forming limited companies, there are a number of formalities promoters or founders have to go through. Then as the companies grow big, they become less responsive to the needs of customers. And also, limited companies may become less responsive to the changes in the environment, as well as become less flexible in structure. This is due to bureaucracy or red tape. But one thing that we bear in mind is that when people start, all these big companies we see, in most cases, it started as sole proprietorship. Then they moved on to private limited companies. And eventually, through initial public offers, they became limited, they become public limited companies. In conclusion, we have to say that the form of business ownership chosen by the entrepreneur depends on a number of factors such as tax, liability, control, and business goals. There's no best form of business ownership. Entrepreneurs choose forms of business ownership that suit their circumstances. Ladies and gentlemen, this is the end of today's lecture on forms of business ownership. When we meet next time or next lecture will be about startups. And this will be on Friday this week. Thank you so much.